sort of feeling of connection with it.
And you will be in Chicago for a performance with the Chicago Jazz Orchestra.
Yes.
And that's going to be a nice venue for a nice event.
Real bad cleanup here. Okay, and you're speaking on the landlord licensing, correct? Okay. Okay, so we've got 10. Yeah, we've got 10 on the line. We have 2 items on our agenda tonight, and a lot of people signed up to speak. We have 30 minutes allotted for each item for citizen comment, and 10 people signed up for P1, that's the landlord licensing. So you will have 3 minutes to speak. There are 15 people signed up for P2 and 30 minutes for comments, so you will have 2 minutes to speak. First of all, we have a quorum tonight. Secondly, approval of the regular meeting minutes of September 10th, 2012. Is there a motion?
Madam Chair?
Yes.
I'm sorry, I don't have my computer open. I'd like to make note that I did not both move and second the Trader Joe's PUD. So if we could make that correction that Alderman Holmes seconded my motion, I think that would help clarify things.
Okay. Anything else? Right. All in favor of approving the minutes as amended?
Aye.
Any opposed? Okay, we have 2 items for consideration tonight. The first is P1. It's Ordinance 38011, amending Title 5, Chapter 8 of the City Code to require the licensing of rental dwelling units. Staff recommends adoption of proposed Ordinance 38011 regarding the licensing of rental dwelling units, amending Title 5, Chapter 8 of the City Code to be effective July 1st, 2013. The Planning and Development Committee considered and accepted the report of the Mayor's Rental Unit Licensing Committee at the July 23, 2012 Planning and Development Committee meeting. This is for introduction, so I'll open it for discussion.
Madam Chairman?
Yes.
Hi, tonight we bring you 38011, a new ordinance that would basically replace the current rental registration or whole building registration program that's currently on the books. Basically, the way the program works today is this is a registration program that's set up much like an invoice system. So for example, for calendar year 2011, the properties will be invoiced in December 2011 for their 2011 registration. The fault of the program and the main deficiency of the program is the registration is not predicated on a life safety inspection being made on the units. The ordinance actually states, upon registration and payment of the fee, the director shall issue a certificate of registration. Exempt properties from that are vacant buildings, lodging establishments, buildings inspected by the state, such as nursing homes or retirement centers, and government-owned and public housing systems. The proposed license program that we have before you tonight is based on a per-unit inspection program. It will be set up based on life safety inspections. The city shall reserve the right to inspect prior to the issuance of these licenses. The most effective way to deal with problem properties, we feel, and problem landlords who choose not to correct life safety problems is to have such an ordinance in place. It also preserves the right for the city to revoke serious and uncorrected life safety issues on properties, or those properties that the police chief has declared a nuisance property. It's modeled after several jurisdictions throughout the state and area, and you'll see those 17 citations in the ordinance. Just this past week, I was in Champaign at a conference and met with an alderman that represented Urbana and asked if they had such a program. He said, "We've had it for 20 years." for apartment buildings. It's the greatest thing we ever did, to the point where about 3 years ago they also adopted it for single-family homes and duplexes. The focus of the program is on rental inspections for life safety issues. If a rental property has code violations, the way we would administer it is that the landlord will be given ample time to remedy the violations before reinspection. For large-scale compliance issues such as the creation of an additional third floor or the finishing of a basement without permits, landlords will be given extra time to submit a plan for compliance to our office. If the property passes, then a reinspection would be put in place, and a certificate of license would be issued. This was last before this committee last year, and you had asked that we put together, and the mayor appointed a rental licensing committee. We met 4 times, and the changes that were consensus made in the document are very much supported by me and law, and I would submit for your consideration and recommendation tonight the update of this ordinance. Again, its primary focus is on problem property or problem landlords that and the compliance of life safety issues. I'll be glad to answer any questions, but I know you have a number of people that would like to speak, so after that I'll be glad to follow it up. Thank you.
Alderman Wilson, did you want to speak? Alderman Rainey, I think you were first.
No, I think he was first.
Oh, okay.
And this is more just along the lines of a comment as opposed to discussing the proposal. I will just comment, having served on the committee, we had a number of meetings and spent many, many hours working on this draft. There were a lot of reservations. There were a lot of concerns. This was a consensus product, and at the end of the day, I think this is about as close as we can get to a workable product for the city staff to accomplish the goals that they were seeking to accomplish when they asked the city council and the mayor to appoint the committee. So with that comment, I'll pass it along for discussion and public comment.
Okay. Alderman Rainey, did you want to speak?
Yes, Madam Chair. I was wondering if Alderman Wilson or Director Griffin could share with the audience and with the rest of the committee, remind us who was on the committee, who served on the committee, so that people can see that it was from a variety of areas.
Are there any folks here tonight in the audience who served on the committee? I did too. Alderman Wilson did as well.
Alderman Rainey, generally it was made up of council members. We had representatives from Northwestern University students. We had landlords and property managers on that, and then we had some area residents. So that was a combination of things. Ken Cox of the law department and I were the principal staffers of it, and we walked through each and every item with this group.
So you would say it didn't lean either way. It was pretty objective.
No, we had some very close votes and a lot of discussion.
Thank you.
Okay, we'll go to citizen comment then. I'd like you to come to the microphone and state your name and your address. And remember, if someone before you has said what you want to say, you can just say you agree with them, or you can go ahead and take your full 3 minutes. So the first one speaking on P1 is Betty Esther, followed by Jill Graham, followed by Bernard Hammer, and Junette Ritsky. Okay, it's hard to tell. Okay, yeah, I thought that was a 1. Okay. All right, Jill, we'll look to see Jill on P2.
Good evening. My name is Betty Esther, and I stay at 2113 Church Street. When this was here before and you had worked on it, there are some things that have been added, which I'm glad to see. It's the one that you are looking at the buildings and inspecting them and talking about life safety. But it talks about this is supposed to be life safety, and somebody said it's supposed to help the tenants. This ordinance, and I still can't see how it is tied to the landlord tenants ordinance, how it's going to give us any really tool or power or anything to come with the landlord besides saying, okay, this building is not safe, he's not doing the water, he's not doing this. This is what we have already under the landlord tenants. I can't see how this is going to help this. The only thing I see it doing for us, the tenants, is that it will cause a slight increase. If they're really mad at the city and they can't hurt you, then they hurt their tenants. But then you're having inspections of one area still more so than you have the other, by virtue of properties that is in the CDBG area. They are inspected every 3 years or every 2 years, where property outside of that area has not been inspected that every 4 years or 5 years like it has been. I have talked to many people that is not in the CDBG area and their property and stuff that do not get inspected. When they make complaints, they said they don't happen. Whether that's true or not, I'm not debating that. But what will you do to the landlord that he has an inspection for a CDBG inspection, and then he comes and says, my renewal is here today. 2 months past, I had a CDBG inspector. Will you require him to come back, have somebody to inspect that building again? If that is the case, then you're aggravating and putting undue burden on both the landlord and the tenant, because the tenant has to be there for both of those inspections. So you need to look at that, and in the CDBG area, I would urge you, if that inspection has happened right before it's time for that renewal, you take that inspection and not make the landlord or the tenant go through a second inspection. Thank you.
Thank you, Ms. Esther. Bernard Hammer, and then Gina Dridsky.
Bernard Hammer. I live in Winnetka. I'm here as an attorney for a property owner in Evanston. She owns a couple of condominiums. I don't know the exact address. In section 581, purpose, this exempts 2 flats, and it exempts, to an extent, multiple unit buildings. There is no reason to exempt an owner-occupied building. You have to give the same protection, equal protection under the law, to the tenant in the owner-occupied building as a non-owner-occupied building. Otherwise, you're violating equal protection as to the tenant. The inspection is an the renting is an activity. And in 583A, this says it shall be unlawful for any person to rent or offer for rent any unit. Now that is a control over an activity of a person, not control of a unit. And as far as the inspection of the quality and the level of satisfaction of the unit itself, that's the building department has to always do it in every city, with or without such an ordinance. So you're putting an overlay merely to get a fee. The city reserves in 7C the right to inspect before issuing a license for that unit. There's no reason to control the licensing unless and until you find a violation. You're doing the restriction and the punishment before you find a violation. And if there is a violation and you have issued a license and you inspect after there's an occupant in there, then you are obligated under the ordinance to give the landlord and lessor the right to correct it. But this is putting the cart before the horse. And again, you're punishing the landlord before you find a violation. You're restricting and controlling the legitimate use of his property. Everybody that has owned property that they don't occupy owns it for the purpose of renting it. In section 585, B, there's a requirement that a description of the violation should include the list of violations, but it just doesn't comply with fairness. You should spell out the violation, not just say the bathroom is inadequate, it violates section so-and-so. You have to actually spell out what has to be corrected, and merely just checking off a statute is unfair and inequitable to the public.
Mr. Hammer, your 3 minutes are up. Do you have something in writing you can share?
Pardon?
Do you have something in writing you can share if you're not finished?
No, I'll yield.
Thank you very much. Janet Ritsky.
Janad Risky. First, I'd like to know if Wally is counting on the revenue from this ordinance, the $500,000, in next year's budget. So I want to know what the motivation behind it is. This weekend, I actually happened to bump into somebody at a small building here, a two-flat, and he told me what the inspectors were inspecting and what they had violations. I'm a licensed architect. I've worked for 30 years in the field, but frankly, I saw that as a bunch of triviality. And really, this is about basically just taking money from citizens, it looks like to me. And yes, there are some people probably that have bad buildings in town, but they're not all the people that have these buildings. It's probably a tiny majority of people. And, you know, there's one thing that troubles me. When you use the term life safety and you're concerned about citizens, you know, I've been very concerned about what you did over at the service building and the violations of the ADA, as people should know that the city knowingly violated the ADA when it moved the television station on the second floor. So when the city sits up here and pretends you're concerned about life safety in these ordinances, you violated the federal law knowingly, and you didn't care about it. So really, what is this city about? To me, this is about collecting revenue. That's all it's about. I don't own any rental property in town, but I dislike things like this that take money from people that have no purpose and basically increase the bureaucracy of the city. Thank you.
Thank you, Mr. Ritsky. The next three speakers are Dan Skirmerhorn, Howard Handler, and Josh Brown. Well, actually, Josh Brown is speaking on P2. Okay.
Good evening. My name is Dan Skirmerhorn. I'm with Skirmerhorn and Company here in Evanston, and I'm here to speak about your item P1. With regard to the licensing of the individual rental apartments in Evanston, I was actually encouraged when the P&D committee recommended the issue be studied by the committee. Unfortunately, the committee did not have the opportunity to study whether licensing was needed. They were just charged with the task of tweaking the ordinance that had already been proposed. And since the committee did not get the opportunity to review the need, maybe we can take a minute or two for that now. According to the information I've gathered at the various meetings that have been held on the topic, including last year, I think Alderman Holmes had a meeting with, we had some university staff, students, neighbors, police department, etc. I've been to the committee meetings themselves, the P&D meetings that led up to the committee being formed, etc. And when the topic was raised, the question was, what are we trying to achieve here? And one of the issues was we've got a lot of noise complaints. We've got a lot of excessive partying going on the properties around the university. But yet when the police officers who were at the meeting were questioned about that, they pretty much admitted that we don't really try to ticket the students. We try to herd them back towards campus, break up the parties, and send them on their way. Now, I went to school in the Big Ten at Indiana University. And we knew that if we were out on the streets causing that kind of trouble, we were going to get a ticket and a fine, and we towed the line. Perhaps if a few tickets were issued, we might solve some of those problems there, not by licensing. We were told we need to get after a dozen or so landlords who refuse to allow inspections, and I'm sure that we have the ability here in the city of Evanston to get a court order to inspect any property where a landlord is refusing. Again, you don't need licensing to do that. We heard that we need to revoke licenses from nuisance landlords, and an example is made if a property had repeated noise complaints that the landlord would be cited under the nuisance ordinance and subject to license revocation. Again, how does citing the landlord stop a noise issue that a tenant is creating? It'd be like citing Enterprise Rent-A-Car when a driver who rents one of their cars goes through a red light. It doesn't make sense. The vast majority of landlords in Evanston work well with the inspectors. I know we do. We have a good relationship with the inspectors, and a relationship that's built out of mutual trust and respect for the work that they do, and the overall desire to keep our properties in good condition, because that's how we keep them rented. It seems like the landlords who comply are the ones who are being punished, instead of those who are not complying being taken to task. As an example, the EPOA asked for a list of all the registered properties in Evanston. When we finally received the documentation, we found that only 68% of the rental properties in Evanston were even registered. What is the city doing to enforce the registration ordinance that's already on the books, much less starting up and licensing on top of it? I'd say we should get a handle on the ordinance we have before we expand it into licensing.
Mr. Skirmerhorn, your 3 minutes are up.
I think I was to speak on both issues, so if I can borrow a little bit of time for the other issue for this.
Can't do it. Sorry.
Well, I hate to be cut off for an issue that's as important to this community as this is.
Do you have any remarks in writing you could share with us?
I do, and I will just close with one item. I guess I've been doing this for too long because years ago we were told that administrative adjudication would bring the problem landlords into compliance. Then we were told registration would bring the problem landlords into compliance. And now we're being told that licensing is going to bring those problem landlords into compliance. Yet, it doesn't seem to solve the problem. It seems like we're penalizing those who do comply, yet those who continue to disregard the ordinance are left to get away with it.
Okay, Mr. Skirmerhorn, thank you very much. Howard Handler, Josh Brown, Jane Evans.
Hello. Howard Handler with the North Shore Barrington Association of Realtors. I'm not going to go into the probably scores of changes that need to be made to this ordinance. I'm not going to go into the fact that it continuously references a realtor's license, even though there's no such thing. It's a trademark name, and there's no such thing as a state-issued realtor's license. And I've brought up how there's conflicting language in the ordinance that conflicts with itself. And that hasn't been changed, but I don't have enough time to go into all that, so I'm going to focus on one major issue tonight. This ordinance strongly conflicts with state law and probably your rental license ordinance on your local law. If a license is revoked today, starting immediately, if the tenant and their belongings are not out on the street immediately, the fines are $14,500 the first week and $17,000 each additional week. Landlords cannot immediately eject their tenants and their belongings from the property. There are other ordinances out there that recognize this. Skokie, which is looking at a similar ordinance, has crafted their ordinance to comply with state law. Mount Prospect has an ordinance that complies with state law. Fort Worth, Texas has an ordinance that complies with state law. We're asking you, please do not knowingly pass an ordinance that forces landlords to choose between complying with local law or state law. And I know staff says, we're not telling you to evict tenants. Don't worry, we're not forcing anyone out onto the street. What they don't follow up with is, you're going to be fined $14,500 the first week and $17,000 each additional week that tenant remains on the property. And, there's probably some good suggestions in this ordinance. But this final product is not a polished piece of product. It's fraught with errors that were not addressed during the committee meetings and that have not been thoroughly reviewed by staff. Please put the brakes on this. Let's go back and let's work out these details. Let's have conversations. Let's adopt models like Mount Prospect or Skokie or Fort Worth, Texas that do not knowingly force people into violating state law. Thank you.
Thank you very much. Josh Brown, Jane Evans, and Mary Rosinski.
Hi, my name is Josh Braun. I just want to state that I'm not at all in favor of adopting this ordinance. Currently, the city has the property maintenance code on its books, landlord tenant ordinance, registration. Each of these items on their own will easily take care of all the issues and probably even more than what this licensing ordinance proposes. And I think it's important that if the city were to focus on actually working and using the tools that they already have rather than adding additional paperwork and problems for landlords, staff, they would probably get a lot of things done. I personally feel also that as nuisance seems to be a hot topic of everything, as Mr. Handler just pointed out, $14,000 a week if you don't get someone out of your property. The fine for a nuisance property or for a party fee, I believe, is only about a couple $100. So if you're trying to control nuisance, I would think that probably raising that fine significantly or raising the range of the fine significantly would probably help a lot in as far as dealing with parties and noise. I also feel that this city is very focused on life safety issues. The property maintenance code is very thorough on life safety issues, and there is more than enough information in that code to easily handle just about anything that this ordinance can take care of, and it already exists on the books. For additional funds, the registration ordinance is already in place, could easily be raised to accommodate the additional fees, to allow for additional funds if necessary. So there's, again, no reason to adopt this ordinance. Lastly, I just would like to point out that the ordinance requires additional inspections. Right now, the city staff can't even handle the inspections that are already going on. So how in the world are they going to handle the additional inspections that are required under this ordinance? So I think as Mr. Handler and Mr. Skimmerhorn presented, I think it's important that this committee review again and strongly trying to determine exactly what their goal is by adopting this ordinance instead of just blindly adopting it. Thank you.
Thank you, Mr. Brown. Jane Evans, Mary Rosinski, Jeff Smith, and Lisa Pildes.
Hi, I'm a member of the mayor-appointed committee.
Jane, could you give your full name and address?
Jane Evans, 813 Gaffield Place. I'm a member of the mayor's appointed committee, and we had 4 extensive and lengthy meetings and did, in fact, come to a consensus, which was pretty impressive, actually. The ordinance is not about noise. It's not about parties. It's about life safety with problem properties. And I am also here as a neighbor representing the Fireman's Park neighborhood. And we are bounded by Sherman to Ridge, Noyes to Emerson. And I was trying to count on my fingers how many homeowners that is. I think I counted 30. It could be a little bit more because I didn't plan for that. We urge the P&D committee to pass this ordinance on to the city council, and we do so because we believe it is always best to inspect first and issue a license after compliance, and it is good for our neighborhood as well as the rest of rental properties in Evanston. Thank you.
Thank you, Ms. Evans. Mary Rosinski.
My name's Mary Rosinski, and I live at 1729 Chancellor. I'm also a realtor on the North Shore Board, and I am a landlord. I would really encourage you to take this back and reevaluate the impact of putting an ordinance that would apply to every homeowner, condo owner in this town. I think it's too much. I think you're trying to solve the wrong problem when you have you already have a means of being able to do it, and you're potentially putting these landlords in conflict, as Howard said, with the state law. And some of these, and I think what you're really going against is maybe very rowdy tenants, and I would agree that there maybe should be stronger deal with the nuisance issue of the tenants. And if you have landlords who don't let you in, deal with them. But please don't pass a law impacting every homeowner in this town and causing potential arbitrary fines when it's not their fault and they've been good landlords. Thank you.
Thank you, Ms. Rosinski. The last 2 speakers, Jeff Smith and Lisa Pildes.
Thank you. Jeff Smith. I echo the constitutional...
Jeff, could we have your address, please?
Sure. 2724 Harrison. I won't repeat, and because I agree with and echo the constitutional objections raised in the North Shore Realtors memo, which I hope you have a written copy of. But I want to add some additional ones. This isn't necessarily constitutional, but the focus, as was said in the introduction of this, is on the problem landlords. But we don't have 14,000 problem landlords in Evanston. We already have the tools to deal with problem landlords. This ordinance, however, would create a regime for all landlords and potential landlords in the city. Secondly, property is a right, and renting it out is a right that is fundamental to ownership. This goes back at least as far as the system of private property in Anglo-American jurisprudence. If you have property, you can rent it out. The ordinance in its preamble, because it's building on the existing landlord-tenant ordinance, frames it as a license, which it says is not a fundamental right, and therefore subject only to a rational basis analysis. I think this is a serious flaw in setting the city up for a challenge on equal protection or due process grounds further on down the line. This is especially so because with 14,000 properties, it's going to be inevitable that there are thousands of properties that are already not in compliance. Because we don't have the inspection and enforcement regime for this, we will have at minimum inconsistent enforcement. We may have arbitrary enforcement, and it's possible that we'll have discriminatory enforcement, or at least the charges of discriminatory enforcement.
Mr. Smith, you're at your 3 minutes.
This is particularly so with regard to the nuisance premises, because somebody can have their property declared a nuisance premise simply because of arrests, not convictions, but arrests on the property. We've seen that you can be arrested in Evanston for being the wrong color in the wrong neighborhood. So we have to have a system where people are not put in peril of losing a fundamental property right because of the actions of third parties when we already have the ability to enforce the problems. Thank you.
Thank you. Lisa Pildes, last speaker.
Hi, Lisa Pildes, 2111 Ridge Avenue across the street. I wear 3 hats tonight. I am a Fireman's Park neighborhood resident. I've been there with my family for 32 years. I'm a local landlord who owns 6 properties in the Fireman's Park neighborhood. And I was a member of the Landlord Licensing Committee. And Mr. Schermerhorn was too. I don't think he mentioned that. I don't believe that case has been made for rental unit licensing is necessary. And although it's been talked about as being a consensus, I voted against it coming out. I don't object to registering rental property and raising the registration fee in order to pay for property standards, inspections, and enforcement. At the committee meetings, the city said the reason for licensing instead of registration is because it would enable the city to inspect units where the landlord had not cooperated or had refused entry. Yet, according to the city at our committee meetings last year, there were only 12 buildings in this category, and there are over 2,400 rental buildings in Evanston. So those 12 buildings equal like a half of 1% of all the buildings, and this isn't enough reason to pass the ordinance. And as already been mentioned, you already have all the laws on the books that you need in order to enforce life safety issues. As far as fees and equity go, in his November 2011 memo to the council on this issue, Mr. Griffin said licensing would enable the city to become less reliant on federal funds. But then in the April 2012 meeting, he said that licensing is not about fees. But I think he was right the first time. His department does not have enough money and personnel to properly administer the current registration ordinance and conduct inspections. Jeff Murphy noted at one of our meetings that the federal money, which is used for the large majority of the department's budget, is getting smaller every year. I don't have any objections to fees for registration. I think they ought to be higher than they are now, and I think it's only fair that those fees should be charged on an equal per unit basis for every rental unit in the city. If it's a life safety issue, it should apply to every rental unit, including owner-occupied 2 flats, and all the multi-unit buildings, including high-rises. And a fee should be charged for every unit. I was glad to see that since our committee ended, the city in the memo that you got sort of teased out the fees that it would do for the high-rise buildings that have, for example, sprinkler systems in it. We didn't have that information. I guess maybe that makes sense, but am I correct in interpreting that the fee then would be $13 for every unit in the building? Or you can't answer me now, but anyway, it ought to be. According to the city, there are about 13,400 rental units, and I think if you collected a fee from every unit, that would be more than enough to supplement the federal funds for a fully staffed and professionally run inspection department, which right now they're trying real hard. I know. There's a catch-22 between tenant responsibility and the license revocation.
Ms. Pildes, you're at your 3 minutes.
Okay. It has been said, we can only do so much to regulate tenant behavior, and we can't evict them as quickly as the fees start to become enforced. So I think that you should raise the registration rental fee and take a few years with some more money to get your house in order. Thanks.
Thank you very much, and thank you to all the speakers. That's the end of our citizen comment on P1, so I'll open it up to discussion from the committee. Okay. Alderman Rainey?
Madam Chairman, I'm wondering, could we have our staff react to some of these comments?
Sure.
I think it would really help.
Yeah. I was jotting some down, Alderman Rainey, if you permit me. The Community Development Block grant inspections are one and the same inspection, so it would be scheduled and put. The apartments are subject to the same license as a single-family home. It's the 2 flats that are owner-occupied that we've chose to exempt. The idea is that when the owner is right next door, they tend to keep it up, and there's, our research is just not that problematic. The question about the sprinklers, yes, that's our suggestion that each of the units in a multifamily building or that have the buildings sprinklered would be to the lesser fee of $13 for each of the units. Irrespective of a lot of comments, this is about life safety. It's not about the routine stuff. It gets the horse before the cart in that we will issue the license predicated on a safety inspection being made. Not every property is going to be inspected. We have a current caseload of about 33 properties that involve about 200 units that are in some state of disrepair, life safety issues, zoning compliance that would be the first round of this. We hope to inspect properties within a 2 to 3 year time cycle, and it would be the same kind of thing where these would be issued. As far as the nuisances and revocation are concerned that was addressed, we see very few of those, but when a property is, and not for parties, but if a property is a property of ongoing crime and crack house, routine, many police calls, it's those properties that we wanted to use this license provision to revoke that, to deal with that. Hopefully, the whole effort is just like it is now, where we focus first with the landlord. We would give them 30 days notice prior to an inspection being made on the property. We're not going to inspect all 14,000 every year. Again, our focus would be on the problematic properties where there's ongoing violations already on the books, and so basically that's the scheme that's set up.
All right. Well, I have something you didn't cover. Is the issue of the nonconformance with state statute, does that have to do with our being a home rule community and we can exceed those regulations, or is it some oversight in our ordinance?
I'd rather defer to City Attorney Farrar when it comes to those legal questions. I have my opinion, but I'll let Grant do what he needs to do.
Chairman Fisk, members of the committee, Grant for our Corporation Counsel. With respect to that, there is the obviously the Home Rule Authority, which is comprised and recited throughout the body of the ordinance. But with respect to the issue of possibly exceeding and or contravening state law, I think that that's touching upon the eviction issue, and obviously the city has no eviction power. That's governed by a private state statute, private cause of action, the forcible entry and detainer statute. So I don't think that that is a conflict, and that's certainly something that the committee, in considering the proposed language, fully explored and came to some discussion and some meeting of the minds, not comprehensive, not total consensus.
So where does that leave us? It's your opinion that we're not.
We are not.
In
that
conflict.
That is the legal department's opinion.
Thank you.
Okay. Alderman Wilson, then Alderman Holmes.
Okay. And I would point out, when we're talking about a nuisance property, that's a defined term. It just doesn't mean that the property is annoying, right, or that something annoying is going on there. Right. So the nuisance, like my microphone, nuisance won't stay out. It's not that kind of a nuisance. It's a process, and to be declared a nuisance, the landlord would have an opportunity to participate in the process and avoid that determination. And if it is just a bad tenant, again, the landlord can participate in the process. There are ways that they can do the things that they need to do to avoid the property being declared a nuisance. And so it's not just a simple question of somebody saying that this property is annoying and now I have to evict my tenant and so forth. The landlord has an opportunity to be involved in that original process. And if it gets to the point where, whether it's that or more significantly to me, the comments were made that, okay, if there are a dozen properties where the landlord won't allow an inspection, okay, sure, we can go to court, file a court case, get a warrant, do all of these things. Right. However, that's a significant burden on us, and we shouldn't have to file a court case, incur our legal staff's time, very, very substantial delays, questionable results in the courts, just to get an inspection. So that's one of the things that has helped persuade me. As I mentioned, I have a number of reservations on implementation, and as a number of people have commented, this was a consensus process. It's not perfect for everyone who was in the room. A number of people didn't agree with it, and but I think this is probably doable, and I think we should go ahead and move it forward.
Okay, Alderman Holmes.
Thank you, Alderman Fisk. I just simply wanted to say I wanted to comment about the whole issue of fees. We don't have a budget yet, so I'm not sure that the city manager is planning on using this in the budget to balance the budget. But I just want to remind people that we've been working on this since 2007. So every year, then we've missed the $500,000 for the budget. So I just think that to continue to say that we're doing this just because of the fee is really just a disservice. I think people that you elect to try to do the right thing for the community. Some of us feel very strongly about it. Me, for one, I've been working on it since 2007 because I think that it is an important issue to have on the books. This is not just about the Fireman Park neighbors, and I want to get that out. This is not just about students. Understand that we have problems all over the community, not just in the Fireman Park area or between Ridge and Sherman and Noyes and Emerson. And I think when we point that out, yes, there are problems there, but there are problems all over the city. And I believe that this ordinance will help us take care of some of that. So, of course, as always, I will be voting for it.
Alderman Rainey.
Well, and let's remember that this is an introduction. We can come back in 2 weeks, and if we interact with some of you and find that there are issues here that need tweaking, we can do that. But I can tell you from the years I've been on this council, the bad landlords have been hiding behind the skirts of the good landlords. We have not done things because of the good landlords. We don't want to offend the good landlords, and believe me, there's nothing I cherish more than a good landlord. But there is no greater burden that a neighborhood experiences than a bad building with bad tenants that, of course, results in, of course, a bad landlord. I have them in my ward. Alderman Holmes has them. Judy Fisk has them. I mean, we just had a series of police reports where in your ward there were severe drug issues. And so it can happen any place. It doesn't have to be south of Dempster or west of Dodge. It can happen any place. So I think that we should try and work through this. What I wish we had were laws that could fine lawyers who stand up here before us and make insightful, ignorant, and slanderous remarks to us. But, of course, we don't have one of those fines. And he knows who I mean. So let's move on with this. And in a few weeks, those of you who have specific issues can call us and we can talk this through. I think it's needed. I think if registration had worked, that would have been wonderful, but it didn't. And so if what I've said in the past, if you're a good landlord, and most of you, 99% of you are, and you wouldn't be here if you weren't, it's really not going to affect you that much. But it will give us leverage where there are bad landlords, and there are plenty of them. But I have noticed lately from members of the committee that those issues that I've had in my ward, the owners are really, really willing to sit down with a few neighbors and the police chief and work through things. So I think things are really improving.
Alderman Nguyen.
Yes, thank you, Madam Chair. I echo all of my colleagues' comments here. Every ward has their bad landlords, and certainly the third ward has suffered with some major bad landlords over time, and it's remarkable when property changes hands, the difference it makes in a community. And that has happened, fortunately, for us in a number of instances. That was simply because the property changed hands. Obviously, we need to have tougher tools so that we don't have to suffer for long periods of time trying to use what we have to help improve a community. So I also support this. And thank you, Alderman Holmes, for all your hard work since 2007. I'm sorry it took so long.
All righty. Is there a motion to send this on to council for introduction?
Second.
All in favor?
Aye.
Any opposed? 5-0. Okay, we're going to move on to item P2, Ordinance 108012, amending Title 5, Chapter 2 of the City Code to require the licensing of vacation rentals. Staff requests consideration of Ordinance 108012, which amends Title 5, Chapter 2 of the City Code to create a license for persons who rent out their homes for fewer than 30 days, commonly referred to as vacation rentals. This is for introduction. Yes, Alderman Rainey.
Did I get a second? Is there a second?
Yes. And we have a bunch of people signed up.
All right. Well, first of all, I was very surprised when I saw this in my packet because I believe it was my constituents who reported that one of our neighbors was conducting a so-called vacation rental. 8, 10 people, 10, 12 cars, limousines with dancing girls coming out in middle of the night, kegs of beer being brought in. We went to the Zoning Board of Appeals. We lost any kind of standard there because Zoning Board of Appeals said we had absolutely no legislation that would govern this kind of rental. Well, I had hoped that at some point we would get an ordinance that would deal with this. However, what we got was probably the most poorly crafted, most uninformed piece of policy that I've ever seen since I've been on the council. The legislation that we were given shows that one of the comments made is that vacation rentals are like lodging, but they're nothing like lodging. Vacation rentals are absolutely, there's nothing familiar with lodging. Lodging has a front desk, they have people wash the sheets every night, they have people checking you in, they have vending machines, they have all sorts of things, they have parking lots, that kind of thing. A vacation rental, according to this ordinance, would be required to have a minimum of a 24-hour stay. A 24-hour stay is not a vacation. A 24-hour stay is a one-night stand. And what that does is it actually allows for very unusual activities taking place in a neighborhood. I don't care if it's a single family, multifamily, whatever. A 24-hour minimum is not a vacation. And it is not something that the neighbors can police. In a lodging establishment or a bed and breakfast, you have constant attention by someone providing oversight 24 hours a day. The neighbors are the police for vacation rentals. Many communities have vacation rentals. Many communities do quite well with vacation rentals. A vacation, let's start talking 2 weeks to a month requirement. A vacation rental is different, and our staff can figure this out. It is different than a long-term rental. A vacation rental anticipates turnover on a regular basis. Every landlord in this room knows that what they pray for is long-term, stable renters with leases that continue year after year. That's not what vacation rentals are. I'm going to ask this committee to send this back to our staff, to remove this from our agenda, and to hold public hearings, please, to hold public hearings so that people in communities and neighborhoods where these things are taking place, where they exist, can come before us and testify as to the ways they think we can make this work. I don't think we can prohibit a vacation rental. I don't think we can. However, we can control them, and that's what we have to do. I will not put up with any more of the nonsense that goes on Dobson, which, by the way, is 1 block from where I live. We just cannot tolerate it, not in this community. I think it can be controlled. I think it can be licensed. I think it can be legislated. But that's not what this is. That's not what this is. So I would like to move to remove it from our agenda and plan for public hearings so that we can develop a reasonable way to control these events.
Okay, thank you, Alderman Rainey. Let's.
Does anybody want to second that?
Well, I'll second.
Doesn't mean you can't say what you think about it.
I'll second it. I think that in the interest of some diplomacy, I understand that this was put together quickly to address some immediate concerns that some people had. So I think that probably accounts for why we got what we got. But that said, I do think that this is going to require a much closer analysis and the participation of the public, who I understand have a significant number of concerns on both sides of the issue. So I think that's that's really the way to go instead of trying to, hustle something through quickly.
Alderman Nguyen?
I share the Alderman Rainey's concerns about this as well, and Alderman Wilson. I think that what we have in front of us tonight clearly was put together in a hasty fashion and doesn't really affect the possible change that we want to have. I understand that I'm actually looking at the internet right now and looking at all these vacation rentals. One of them is in my ward. They even show the address on it. I do think that we need to have a better discussion about this. I understand folks who live in R1 and R2 districts that this is not what you thought you were buying your property next to, that you didn't think you would have a commercial operation next to your house, and there has to be some way to control this. So I agree, and I do think this needs a little bit more discussion. We can't always make the instant changes that people would like to have. We need to think things through because sometimes we cause more problems than we're trying to eliminate. So I agree with you, Alderman Rainey.
Okay, we do have people signed up to speak on this tonight. You may speak or not speak at your discretion. I will call the names, and you can come up and address us. You have 2 minutes for your public comment. The first is Julie Kaler, followed by Greg Richards.
Alderman, you can, Alderman Rainey, prohibit these vacation rentals in your home, in your wards. In fact, you already have prohibited them. It is inexplicable as to why the city is creating this debate over something that is already prohibited within your municipal code. I have been a criminal defense attorney for over 16 years. It is my job to interpret and read statutes and ordinances. And I'm telling you, there already exists in your municipal code. It's a section entitled Chapter 5, Home Occupations. This chapter defines what type of businesses can legally be run out of homes, depending on what their zoning distinction is, R1, R2, or R3. Prohibited in all zoned areas are businesses providing shelter and lodging. That's why you all had to amend the code to allow bed and breakfasts, because otherwise the running of a bed and breakfasts involving overnight guests would be considered an illegal home occupation. You had to amend the code to allow that in each of the zoned areas. And you all understand this point. The zoning committee will need to make a text or code amendment to include this vacation rental as a special use before the ordinance can go to the city council. The very fact that you have included this term of use, or as you called it, this business, shows that it is a legal business already being run out of a dwelling as already defined within your municipal code. It is an illegal home occupation, and it already is prohibited in any R1, R2, R through 6. You cannot run an illegal business out of your home that involves overnight guests, that provides lodging or provides shelter to people. And that's exactly what these homes are doing. They are renting advertising on the internet for people to come and stay temporarily in their home. Want a place to throw a party? Rent a home off the internet in Evanston. Rent a condo off the internet in Evanston. According to this new ordinance, all a vacation owner rental house owner needs to do is keep a log and change the sheets in between guests.
Ms. Kaler, your 2 minutes are up.
Thank you, but I would just like to ask that when you do propose this ordinance, you look at your existing ordinances, your existing prohibitions in Chapter 5 against what is allowed as a use or special use in each of these zone areas. And right there, in black and white, it says, no home occupations involving overnight guests.
Thank you, Ms. Kaler.
Thank you.
Greg Richards.
Good evening. My name is Greg Richards. I live at 2529 Ashland Avenue. And I would just like to state my strong opposition to any statute or ordinance that gives a homeowner in a residential district like mine the right to turn their home into a hotel. We don't allow hotels, we don't allow rooming houses in residential districts like mine, an R1 district, and those restrictions were put in place for very good reasons after due process, and so I don't understand why we would allow a homeowner to undertake substantially the same activity out of their home. Unfortunately, this is what a young couple down the street from me has elected to do. They are renting out rooms or the entire home for nights and for weekends. You can rent one room for $65, another room for $75, or you can rent the whole home for $400, unless it's a Northwestern football weekend, in which case it's more, or unless there's more than 5 people in your party, then the cost is more. You can just go online. I have printouts of the internet ads with me. You can book the room online. Checkout time is 11 a.m. So I think it's pretty clear what the activity is that's being undertaken is here. I have 3 children under the age of 6, and there's probably 13 or 14 other children, young children, on my block. St. Athanasius School is right across the street from the home in question. Kingsley and Haven schools are within 2 blocks. I don't want somebody on my block operating a de facto hotel. It's making my neighborhood less safe, and I don't think you would want the person who lives next door to you doing the same thing with their home. So this is not legal activity, and I don't want the city to regulate it. I want the city to enforce the existing code and put a stop to this. Thank you.
Thank you, Mr. Richards. Kim Novi, Mark Rosati, and Maureen O'Donnell. I hope I have that right.
Good evening. Kim Novi. I live at 2507 Ashland. I think one of the things that you're all hearing tonight is that there's been a lot of frustration from my neighbors, basically the Ashland and Central area. We've been getting so much conflicting information. We call the city tells us one thing. We try to get in touch with the Corporation Council, we get another piece of information. We've been told that Judge Shader in the Dobson case has forbid the city from enforcing its laws against what Julie was talking about, allowing these homes to be rented out. I'm an attorney, I've looked at his rulings, I've looked at the TRO. That's not what happened. All he said was you can't continue to issue violations once one has been issued. So we'd ask respectfully that the city enforce the ordinances that you already have. They forbid this, and we ask that you do not allow any expansion of the vacation rentals. Thank you.
Thank you very much. Mark Rosati and Maureen O'Donnell.
Thank you. Mark Rosati. I live at 2500 block in North Ashland. In the interest of time, let me just say I agree with what the previous speakers have said. We live next door to one house that has been renting rooms on a transient basis for several months. 2 doors down, another neighbor has told us that she is also considering doing this. This would mean that 2 of the 16 residences on our block would be renting to transients. There's been a stream of people in and out of this house. I have a teenage daughter. I no longer have any idea who is living next door to me from one day or night to the next. One benefit of living in a residential neighborhood is that you can look out for each other, but again, if you don't know who's living there, you don't know who has the right to be in a yard or entering a house or in the alley. This is happening near elementary schools. I think this would be very bad for business, very bad for current and prospective property owners. We would never have moved into Evanston if we knew that with no notice, the house next door could become a transient hotel. So I think that this is something that the city should prohibit and enforce the existing law. Thank you.
Thank you very much.
Hello, my name is Maureen O'Donnell, and I live next door to 2515 Ashland, which is offering rooms and for overnight rentals.
Maureen, could you just state your house number?
Yes, 2509 Ashland. I live next door to the home that's offering single rooms for as little as $75 a night, sometimes $55. Additional guests are invited to stay for $15 a night. That is cheaper than a flop house. There is no way to thoroughly vet transient tenants to check for criminal background and sexual predators. As my other neighbors said, we have many children on the block, St. Athanasius School, Kingsley and Haven School. How can we feel safe when the House rules for these ads say, let your moral compass guide you and will be good. Some of the other house rules are no screaming, fighting, or pulling hair. I'm sorry, but I don't find that comforting, and I don't think that protects our children. The website that's offering these transient rentals, Airbnb.com, recently had to pay a $50,000 settlement in San Francisco to a woman who used them to rent out her home and came back a week later to find it destroyed and littered with crack pipes. This was the subject of many articles in USA Today and San Francisco newspapers. I moved to Evanston for its schools, its lake, its cultural offerings, and my neighbors, not to live next to an illegal transient hotel and feel that our children are unsafe. The attorneys in our neighborhood believe that this and other illegal rooming houses are covered by already existing legislation. We don't want it regulated. We want it shut down. Thank you.
Thank you very much. Okay, Sarah Gompers. Christy Bollier, is that how you pronounce it? Christy, are you here?
Hi, I'm Sarah Gompers. I live at 2680 Prairie Avenue, so not on Ashland. I am very concerned about this issue, though. I have 3 small children, all under the age of 5. I see your issue here with vacation rentals. I would love for more visitors to come to Evanston. I think that it is a wonderful place. I'm proud to live here. Renting for a month or a year is one thing, but I live on Prairie. I do not live walking distance to the beach. Who is going to go on vacation on my block? I'm about a block from Dominic's, so that's about what you can walk to. You can get some great coffee on Central Street, but again, if I want people renting on my block, I want them to be there. I want them to be my neighbors. I do not need people renting for a week or 2 weeks. I need to know who lives on my street. That's why I own my house. Thank you.
Thank you, Christy. Sarah. Christy Bollier, are you here? I'm saying your name wrong. Okay. Jim Mullen, 2525 Ashland. I'm trying to read. And then Jill Graham, and then Tom Wilson.
My name is Jim Mullenix. I live at 2525 Ashland. I'm the husband of Julie Kaler. And I'm a former public defender. Ms. Kim Novy is a former prosecutor, and she stole my thunder. She's talked about what I was going to talk about. It's not the first time a public defender has been one-upped by a prosecutor. In any event, I won't talk about that issue concerning what Judge Shader did not say in the Davies case. I will quote, however, from Ms. Davies' attorney, who I believe was here earlier and spoke in favor of P1, representing all the landlords out there in Evanston, when he said, "We already have the tools, therefore P1 is not necessary." I agree with him on that point. On this particular point, too, because on P2, this proposed ordinance, I agree with Ms. Kaler and Ms. Novy and everyone else who has spoken out against it. We have the tools, we have the laws on the books. If you look at the zoning code, and the first chapter talks about the purpose and intent, and I'm not going to read it here, but 2 of the things they talk about is to promote and facilitate the public health and safety of the residents and to maintain the current property values. So let's not forget about the decline in property values. Who wants to buy a house or a condominium next to a transient hotel? The short-term rental business isn't underground, and this business can't go underground. All you need to do is type in Evanston in the search engine on Airbnb, and you'll have every location of every transient hotel in town. To stay alive, they must advertise. The housing market may have crashed, but that does not mean that one neighbor can bring down the property values of surrounding neighbors, strike that, homes, or endanger the safety of other neighbors by operating an illegal business out of their home. There already exists in Evanston's municipal code a prohibition against this problem. Throw out this unnecessary ordinance and enforce the laws that are already on the books. Thank you.
Thank you very much. Jill Graham and Tom Wilson.
Jill Graham. I live at 2439 Ashland. I'm a retired business school professor, and I look at this not only as a neighbor, but also as a business proposition. And it seems to me that businesses ought to be located nearby other businesses that they might be related to. And when people need a place to stay, well, that ought to be near places to eat, for example, and hotels maybe ought to be near restaurants. We zone for that sort of thing, don't we? We put commercial establishments near other commercial establishments, and people live in residential districts. That's why zoning exists. And you get a business license to do business. And that's as it should be. As everybody else has said, that's what should be enforced. And it seems to me that that's a good way for businesses to be run. And if somebody wants to run a rooming house or transient hotel, incidentally, I think you ought to include in this proposed ordinance, as it hopefully is revised if it's to be resurrected at all, you need to define guest, transient, as well as guest, permanent. If there's going to be such an establishment at all, perhaps they could be located elsewhere in town, so that when people search on the internet for them, they could find a place to stay. Coming in for the football games that are listed in the Craigslist ad that has been referred to, listing all the home games for the Northwestern football team, so that you could come and stay right down the street from where we all live. And incidentally, you'll be provided with large coolers filled with ice to keep whatever you're drinking cold, a grill that is hard-lined to the building, so you need not worry about running out of gas on a long grilling day. Do I hear a party? And just invite your friends over and have a wonderful time. And, there are parties. We all have parties from time to time, and that's great, as long as we're all neighbors. And so if it's too noisy, we kind of nudge each other and say, could you keep it down?
Ms.
But that's
Graham,
because we know each other.
You're at your 2 minutes.
If they're strangers, it's kind of hard to hold one another accountable. We all want to be friendly neighbors, not strangers who are leaving town the next morning. Thank you.
Thank you very much. Tom Wilson. Okay, thank you. Dan Skirmerhorn, Howard Handler. And okay, thank you. I'm sorry, Howard. Did you wish to speak?
Just briefly.
Okay, thanks.
Again, Howard Handler with the North Shore Board of Realtors. We're not here to, our association is not here to oppose or support this ordinance, but I did want to give you a little feedback on the ordinance. It really fails to distinguish between people that are engaged in constant, regular renting of their dwelling versus those that might need to in a situation here or there. I just gave a couple examples. One is a couple sells their house and they close on November 1st, but they're unable to move into their new house until November 15th. So they arrange with the buyer to rent their home, the new buyer, for 2 weeks. That's actually very, very common in property sales. My father almost had to do that. That would be unlawful under this ordinance unless they went and got a license and submitted floor plans and changed the sheets once a week. Another home, if a family undergoes significant flooding in their home and their first floor is uninhabitable and the contractor states it will take 3 weeks until the house can be safely occupied again, and there's a house down the street that's on the market but unoccupied, and they arrange with that owner to rent out the place for 2 or 3 weeks until their carpeting's put in and the contractors finish their work. That would be unlawful under this ordinance, again, unless they went through the whole entire process, which is a pretty tough process. Or a Northwestern professor leaves town for 3 months, and at the same time, he leaves town for a sabbatical. And a family originally from Evanston but living in California or Europe wants to come back and spend a week or two in Evanston. And a mutual friend knows both of them and introduces the two parties, and they work out an agreement. That would be unlawful under this ordinance. So I think what you have to go back to is, if an ordinance like this is going to be moved forward, is to really distinguish between people that are engaged in the day-to-day and day and week after week rental of properties versus someone that might need to in a crunch situation.
Thank you very much. Okay, now I have Judy Kaler. That's not Julie, it's Judy.
Good evening. My name is Judy Kaler. I'm the president of the Jeffersonian Condo Association, located at 2425 Central. It's across the street from Ackerman Park. Now, we are opposed to this vacation rentals for purposes of time, 2 reasons: safety and value of our property. How would it affect our safety? Our condominium, like most condominiums, is security controlled. It's totally locked. We have a security system. It doesn't run with a key. You have a code that you punch in to get into the building. We have 2 condominiums that have absentee owners. What if they wanted to rent it out to get enough money to pay their dues yearly? So they rent it out. This is in an area, in a condo building that allows rentals. They rent it out. They give the transient the code to get into the building. The transient gets into the building with the code. That transient then not only has access to the condominium that they are vacation renting, they have access to the party room, they have access to the garage where all of our cars are stored. Maybe they'll want to put their car in the garage too. So they spend a night there, they're 24 hours. They get up the next morning and they leave, and they take the code with them. So you have a transient there every week for 50 weeks. There's 50 people with our security code.
Ms. Kaler, you're at your 2 minutes.
All right, I want to close, if I might, because I believe I'm the last. No, all right, well, I will close. So we have no control over that. But what we are asking is that you not adopt this vacation rental because of the safety of our residents and because the deterioration in property values. Just think what it would be like to live in a condo building with a party going on. And we do not want that, and we oppose this ordinance. We would appreciate. Oh, you talk about bad landlords? What about a bad absentee landlord that lives in Oregon? How are you going to reach that one?
We need to quit here.
Thank you.
Thank you. Okay, Kim, is it Kim Quinn? I can't really read very well. And Omer Temesiel? Jeff Smith? And that's the end.
Hi, I'm Kim Irwin. I live at 115 Florence.
Mm-hmm.
I live across the street from the Dobson property that generated a lot of this controversy. Thank you, Ann Rainey, for advocating for us. I'm not going to duplicate what's been said here. It was a nightmare living across from 1525 Dobson, and I'm glad that apparently she's changed her relationship, at least temporarily, with her rental agreements. I do think that I know people in Evanston who genuinely have a problem financially, and so somehow we have to find a way to make a distinction between people who need boarders and to take in boarders to help make their mortgage, which seems like a legitimate thing to do, and people who like flat out move out and rent their property out for vacation rentals by the night. Like there has to be some way to find language and a legal structure that allows people who want to be responsible but have a boarder and distinguish between those people who are kind of abdicate their responsibility for managing their home and being on site and allowing anybody to come in. That's all I wanted to say.
Thank you, Ms. Irwin. It's Omer Temesiel. Temesiel? Did I pronounce that badly?
My name is Omar Temesiel, 1521 Dobson Street, Evanston. We had the peaceful neighborhood, but after a vacation come next to us, After that, I wake up every day with different neighbors, sometimes 19, sometimes 5, sometimes 6, sometimes a family. I used to spend most of my time in backyard with my granddaughter or my daughters, but not anymore. People stay overnight, very crowded. Sometimes they use backyard as a toilet. I witness it, and I am not happy. I don't want city regulate this vacation home because rental home is different. If you want to rent a home, you have to check neighborhood, you have to check school district, everything. How to go? They come for one night, they disappear another, and they check in themselves. No one controls them. And they check out themselves. Next month, other year, this kind of vacation homes will be hiding places for criminal. Even I am thinking about selling my home and go another place. Thank you.
Thank you for your comments. Mr. Smith?
Thank you. Now, Jeff Smith, 2724 Harrison, and I believe I've been alluded to in several comments earlier here. The last 3 times I've stayed in a town with a major university, I've stayed at a short-term rental or vacation rental. A couple times found it on Airbnb. It was for only one night. It was with a woman I've been married to for over 30 years, so I don't consider that a one-night stand. So if we want to talk about ignorant comments, we could be here a lot longer. I was also the attorney who appeared before Judge Shader. The characterizations of his ruling have not been accurate. We never reached the merits. It was decided on a very narrow rule of procedure. And but what he did say, and it wasn't in the opinion, was that we should all be aware and beware of the heckler's veto when government is stampeded into doing something based on hastily formed opinions or fear, even if those fears are well-grounded. We have real problems in Evanston. We have real crimes. We have real people being subject to physical abuse and worse every week. And I think if you added them up, you'd find that the number of those crimes that are being committed by guests and visitors to this city is a very small proportion and arguably even disproportionately less than the people who live here. So the public safety fears, I think, are somewhat exaggerated. Now, Alderman Nguyen made a great point. Nobody moves in expecting to be next to a commercial property when you move into an area that's not zoned for that. We all agree that you can rent out your property for a year, 3 months, probably a month. At what point does it become commercial? We haven't drawn that line yet. And I don't mean to say anything one way or the other about the Ashland situation, because if they're renting out individual rooms, that's a different situation than occurred in the Davies Dobson situation where somebody's renting out their own homes.
Mr. Smith, you're at 2 minutes.
Okay, thank you. We need to look at the property values situation. Sometimes we're keeping property values up. When you take away a use from a house, most economists would say you're driving property values down. The ordinance is a good start. In this case, I agree with Alderman Rainey that it should probably go back for more discussion, but it should be a balanced, open-minded discussion. Thank you.
Thank you very much. Okay, he was our last speaker. Who was first, Alderman Nguyen or Wilson?
Yes.
Alderman Nguyen, and then
Yes,
Alderman
thank you. Jeff, economists are not zoning lawyers, so they may say they're just speaking from a pure economist standpoint. They're not living in a neighborhood. I'd like to point out to all of you who are here that over the summer, this council had a rather intense debate about bed and breakfasts. Only 2 of us on the council supported making changes in terms of it being owner-occupied and having a distance requirement. Almost every single one of the comments that you all have made were made by 2 of us here on the council about wanting to know your neighbors, wanting to have a community that was the community that you bought into. And I share all of your views. The only thing I'd say is that any neighborhood in Evanston that's zoned R1, even if it might be by the lake or near an attraction, really should be respected for the fact that it's R1. So I support all of you. I understand perfectly your concerns. And if any of you are interested in the debate that happened over a bed and breakfast, I urge you to go back and look at it, because it's going to come back. And all of the issues that you are raising are ones that two of us here on the council raised, about knowing your neighbors, not living in a district that suddenly becomes commercial, and having some distance requirement, and requiring the owner to live in the bed and breakfast at the same time as they have guests, for all of the things that you have just described. So thank you for raising these issues, and I think we're going to work on this.
Alderman Rainey?
Well, the vacation rental that I'm familiar with is nothing like a bed and breakfast. There is no supervision. There is no maintenance requirement. There is nobody there 24 hours a day who has any relationship to the property in terms of a management relationship. I don't really care if it's an owner who lives there, a manager who lives there, or a clerk who lives, somebody who lives there and oversees what's going on at that property. In this case, it is absolutely a free-for-all. There's a vacant house, a bunch of people move in, a bunch of people move out. I've not really given much thought to the danger problem, to people who are afraid of who's going to live there. But there's no parking issues. There's no control over any of that. So that's really a very different situation than what we have down in the south end of town. The Zoning Board of Appeals failed us. The Zoning Board of Appeals said there is absolutely nothing that restricts in our code that restricts people from conducting themselves and renting out their house on Craigslist or wherever. And so that's what happened. We felt there was something in our legislation that would help us, especially in the zoning code. They said no. I wish the Dobson neighbors I know wish they had known you were out there, because the only appeal you can make on a decision by the Zoning Board of Appeals in this case is to circuit court. And I don't believe that the Dobson neighbors, and I'm not speaking for them, but I think I recall they're not feeling able to take that step. Lawyer jumped in, and we have a pro bono volunteer here. A lawyer stepped in, scooped up Mrs. Davis, and that's when all the legal stuff started. So that's where we are. I have no idea how to interpret Shader's comments. I haven't read all of the information, hasn't been made available. But, if you all think there's something we can do that will, that's why we have constituents, so you all can come and talk to us and help us. So I'm looking forward to having a free discussion, and all of you great legal minds out there can help people like me who have this problem in my ward. I look forward to it. So having said that, if there's nobody else, can we just move it off our agenda and everybody can go home? And
Okay, Alderman Wilson, did you want to say something? Okay, then we're taking it off the agenda, referring it back to staff.
Let's vote.
And we'll vote on that. All in favor? Will someone make a motion, please, to do that?
I move that it be removed from our agenda for the purpose of having some public hearings and discussions regarding how to move forward.
Okay, and we'll have the public hearings here at this committee.
Sure.
And there's a second?
Second.
Okay, all in favor?
Aye.
Any opposed? Okay, there it is. Thank you, everyone who came tonight.
Are we adjourning?
And, well, wait, we have no items for discussion that I know of.
None.
Are there any communications? Wait a second, everyone.
Wait.
Just 1 second. Let us just take 1 minute to finish our business. Any communications?
No communication.
All right, is there a motion to adjourn? Okay, City Council will begin at 8:55. Okay, so I've written all over your agenda. Sorry.
Oh, what are you talking about? You did good.
And this is...
You can have all.
Kingsley Bates's line of high-quality heirloom teak, Britannia's collection of contemporary woven deep seating and dining furniture, and Parker James' affordable and modern dining and seating. In addition, the Statuary Department's annual parking lot sale is back at Gethsemane. Assorted planters, bird baths, and statuary items are priced for final clearance.